and for posterity's sake. So thank you very much for joining us from wherever you are. Today, I have the pleasure and privilege of welcoming and introducing Professor Khaled Fahmy, a historian of the modern Middle East, who specializes in the social and cultural history of 19th century Egypt. At the University of Cambridge, he holds the Sultan Qaboos bin Said Chair of Modern Arabic Studies. And today he's going to be addressing one of his books, but it's one that comes in a series of works that he's been providing us, all of us, on Egypt. His first book, All the Pasha's Men, was published, offered a revisionist account of the army that Muhammad Ali Pasha founded in Egypt. Following from that study, Professor Fahmy's second book, Muhammad Ali, From Ottoman Governor to Ruler of Egypt, examined the unprecedented economic, military, and social policies that Muhammad Ali introduced in Egypt, as well as Muhammad Ali's intricate relationship with his family. The book is a critical biography of this 19th century huge personality. Professor Fahmy's latest book, which he'll be talking to us about today, is called In Quest of Justice, Islamic Law and Forensic Medicine in Modern Egypt, published by the University of California Press just in 2018. The study, which hopefully some of you have had a chance to read, and I have too, seeks to understand how an Arab Muslim majority society encountered modernity. Rather than following intellectual, diplomatic, or economic history, In Quest of Justice approaches this question from the perspective of cultural history. Specifically, it takes the human body as its unit of analysis and checks how the body became the site of contestation, the locus of agency and resistance, and the subject of new medical and legal discourses. In 2019, the American Society for Legal History awarded the book the Peter Gonville Stein Award for Excellence in Legal History at its annual meeting in Boston. Today, Professor Fahmy will speak to us about this most recent book. Incidentally, his lecture today is part of his week-long engagement at the Institute of Islamic Studies. As some of you know, we host visiting scholars annually to join us here at the Institute. This year, due to COVID, the joining is virtual, but in addition to today's lecture, Professor Fahmy will be leading a masterclass starting tomorrow over the course of the week with graduate students who have already applied, been doing readings in advance, and have already been issuing writing responses, and they will also be joining us here today. So with that, I want to thank Professor Fahmy for joining us all the way from his home in Cambridge, and I will turn over the event to him. Thank you, Professor Fahmy.
Well, thank you very much, Professor Imon, and thanks for this wonderful introduction. If you do not hear me clearly, please indicate so by raising a hand or doing something. But I also I thank the Institute of Islamic Studies for inviting me. I look forward to participating with the students over the coming 3 days, reading the response papers and meeting them over the coming 3 days. And thank you all for coming. Of course, I know that there is much more exciting things happening, especially south of the borders, but maybe this lecture can give you some distraction and respite from what's happening elsewhere. This is I've always had difficulty talking about this book. I've worked on this book for 15 years or even more. I can't even remember. And I think I've lost all critical distance from it. So it's difficult for me to talk about it. And rather than articulate or summarize the arguments or one of the central arguments in the book, the one in chapter 2, repeated or elaborated in chapters 4 and 5, I want to, which is basically how social history can help us understand the wealth and enormity and depth and intricacy of Islamic law, how one can adopt a social history approach to understanding law. So it's not law as jurisprudence, but law as practice. And specifically, given that I'm a social historian, I want to follow how average, and as we will see, less than average people actually understand the law and appreciate it. And my case is that of 19th century Egypt. And again, rather than summarizing my argument, I thought I would share with you a personal story, share with you the story of the book rather than the story that the book tells. So I want to tell you how it is that I ended up with this project, and I want to take you into my thoughts, my reactions, my ideas, and my findings in the archives. And I also want to take you in some details into what is it that we do when we do Islamic legal studies using archival material rather than textual sources. And my archival material is a bit peculiar because they're not the familiar Sharia code archives. They are the records of a peculiar system that I want to talk about. So how did the project start? Well, it started actually all the way back when I was working on my first book. And it wasn't about law, it was actually about medicine. For those of you who may have read this book, there is a chapter in this book that deals with medicine. It's the 5th chapter that I try to talk about the soldiers in Mehmed Ali's army using medical records that I found in the archives that I thought allowed me to get to the lived experience and the dead experiences, if I may say so, of the soldiers in that army. And that is what triggered my interest in medical history. And from that, when I finished this project, I had already started encountering medical records in the archives, not only military ones, but civilian ones. And I was asking friends in the archives, and this is what we do, the archives in Egypt, as elsewhere, you know, it really works by interacting with other researchers, and especially in Egypt because there is no good index, an indexing system. So we rely on word of mouth. So I was telling people that I'm interested, my fellow researchers, that I'm interested in the social history of medicine. I was particularly interested not in the grand narrative of the European physicians who came to found the modern medical establishment, or Mehmed Ali and what his purposes were. This we knew. But how did average Egyptians react to something like vaccination against smallpox, or quarantines like today's quarantines, or most interestingly, dissection? And dissection for me theoretically was peculiar and intriguing because it touched on religious dogmas, the questions of religious dogma and the sanctity of the body. And so I was asking people around, and someone told me, why don't you look into legal sources? I said, what legal sources? He said, there are police records, but there's also court records in the archives that may have information about medicine. And I said, can you tell me more? He said, yes, there are records of something called Majlis al-Ahkam. I hope you excuse my Egyptian pronunciation, so I will call it Majlis rather than Majlis. And Majlis al-Ahkam cases have, many of these cases that are criminal cases have medical reports embedded in it. So I said, okay. And he said, we're talking about thousands of records. And just to share with you a picture that I later on discovered of the stacks in the National Archives. Now, these are the stacks, not of the whole archives, obviously. These are the legal section. And the records that I'll be talking about look very much like the one on the right with these measurements. Just to give you a further example, this is a photocopy of one case, and it's kind of that measurement, if you can see if you can see it to scale. But I think this picture illustrates it better. So we're talking about, and he told me there are 312 registers of Majlis al-Ahkam. Majlis al-Ahkam has thousands of registers, but there are 312 registers that are peculiarly interesting for your purpose because they have what they call al-madabit al-sadira. These are the records of actual cases. They're the actual records of this case. As I will say in a minute, Majlis al-Ahkam function as a Supreme Court. So these are very serious cases, mostly homicide and other criminal cases, that were adjudicated by lower majlises and were funneled upwards to Majlis al-Ahkam. And there are 312 registers. Each one, you can see the pictures on the left. I'm not sure that these are actual registers of Majlis al-Ahkam, but they look like this. And each one of these ledgers has, on average, between 120 to 150 cases, sometimes more, sometimes less, depending on how long the case is. And these registers cover a period from the 1840s, the mid-1840s, to the early 1880s. So it's about 40-year period of fascinating cases that are very legibly written and having amazing amount of detail. And there are many other registers of Majlis al-Ahkam alone as one archival unit. There are outgoing registers, there are incoming letters, there are personnel records, there are financial records. It's a huge amount of, really thousands of cases, of registers of this Majlis alone. So I said, okay. So I went to Madame Sausan, who was at that time the head of the reading room. Now it is Madame Nadia, her disciple and successor. Madame Sausan is a matriarch of the archives. I went to her and I told her, can I have access to the first registers of the Madabit al-Sadira of Majlis al-Ahkam? And sure enough, I started reading them. And these are not indexed, so you keep on reading one case after another. And I think in the first or 2 weeks, I hit upon, I started realizing this is a life-changing experience. This is very exciting. What I'm reading is like out of this world. The details and the erudition and the number and the sheer volume. And I thought, like I'm a kid in a candy store, or like, Magharat Ali Baba, Ali Baba's cave, so many treasures that in front of me. And I want to zoom in on one case. It's a case that I write about in my book, In Quest of Justice, in the 5th chapter, rather than the chapter that I'll be talking about today, which is chapter 2. But this case I write about in chapter 5. The case, for those of you who are interested in actually reading it, I have a transcription of it in another book of mine in Arabic called Al-Qasad wal-Hadatha that was published in 2004. So that's how far back I have been working on these cases. In this case, I, with no exaggeration, really shook me to my core and maybe even changed my life. I don't know. I don't want to exaggerate, but let's see it. So this is what the case looks like. It's 2 pages. It's 75 lines. The last line actually belongs to a 3rd page, but that page has only 1 line, so I transcribed it in my own handwriting at the very bottom of the page on the left. What is this case? The case starts, so I'm going to take you into the details of this case for a long time, so bear with me, but I hope you don't get really lost or bored in it, because this is really I think, a case that tells a lot of the ideas that I want to dwell upon. The case starts by saying that we in Majlis al-Ahkam received a report from the police headquarters of Cairo about an incident that they had witnessed. The case happens in 1858. Earlier on in that year, they say a slave by the name of Abd al-Zain al-Aswad walked into the police station to say that he was a slave working in an estate that belonged to Ilhami Pasha. Now, I want to show you who Ilhami Pasha is. So Ilhami Pasha is this guy here. This is the ruling family. The estate, the incident happened in the reign of Said Pasha here, as you can see his dates here. It happened in 1858. And the estate belongs to this person. So the estate, in other words, is a princely estate belonging to a prince who is basically the grandnephew of the governor of Egypt, of the ruler of Egypt. So it's a very important estate. The estate is at the outskirts of Cairo. This is where the estate is. Now, this is a much later map. This is a map from 1914. So the case happened 60 years earlier, before this map. So if you can imagine, Cairo had not even expanded that much. Cairo was limited only to this area. So the estate, when the incident happened, was really literally in the middle of the desert. And Cairo itself is here. Let's imagine it borders this area. The Cairo police headquarters is marked here in green. So Abd al-Zain al-Aswad walked really in the long distance in the middle of the desert, crossed into the gates of Cairo, walked to the Cairo police headquarters to say that the overseer of the stables of the estate of Ilhami Pasha had beaten to death a fellow slave. And while he was giving details of this incident, 26 other slaves stormed into the police station, saying that they too belonged to the same estate, and they too came to speak about the same incident. What the 27 slaves in total were saying was the following. 3 days earlier, Omar Bey Wasfi, the overseer of the stables of the estate, had ordered one of their fellow slaves to be beaten. That slave's name is Sultan, which is a wonderful name for a slave. Sultan had taken leave to go to Cairo proper a week earlier for 1 day. But he was late in returning to the estate. So to teach him a lesson, the overseer decided to beat him. But the beating was excessive, was too excessive. Some of the slaves said that he was beaten 300 lashes. Others say, no, it was 600 lashes. And then one of them, Bekhit, says, the groom, said that he was beaten 1,500 lashes. And here is the part in the story where he says this. He says that he was carrying a worry bead with 99 beads, and every time it made one loop, he would extend one finger. And by the end of the beating, he had extended 15 fingers. That's how he remembers that it was 1,500 lashes minus few. They added, saying that Sultan was crying and screaming, started vomiting blood. That blood was dripping all over the place. That flesh was peeling off his buttocks. And that after the beating was over, Omar Bey Wasfi ordered him to be taken into another room, put in shackles, and poured molten lead on the locks of the shackles and prevented him from eating or drinking for 3 days, at the end of which Sultan perished. They were terrified because they remembered that Omar Bey Wasfi, the overseer of the stables, had earlier, the previous year, done the same thing with 2 other slaves. So they were fearing for their own lives that any one of them can be next. That is why they came. They also said that before leaving the estate, they made sure that the body is not buried. And they prevented the local nurses of the hospital or the nursery or the clinic of the estate from coming and cleaning up the body and burying it. And the local undertakers of the region, of the locality, also hearing of the incident, decided they're not going to participate, they're not going to obey the orders, the summoning, to bury the body. The slaves requested that the chief medical officer of Cairo Police Headquarters comes with them to back to the estate to investigate the matter. That medical officer did actually go, and we see him giving his report on what he had seen on the body, saying that there are clear signs of external beating, of contusions, of an internal hemorrhage, although and further investigation has to be done through an autopsy. The body was sent for an autopsy, and I know where that was, in Qasr Al Aini Hospital. His report was not conclusive, but about the cause of death, but it raised serious doubts that were later taken on by Majlis Al-Ahkam. Now, for me, when I was reading up to here, I thought this is just horrific. I remember I was really shaken by these details, to the degree that when I went and saw a friend of mine and told her the case, she actually thought that this is happening in Cairo now, which is not very far-fetched, sadly. But I told her, no, this is a case I read in the archives. She said, well, you should have told me. I said, well, it's just very serious. I was really, really very shaken by it. And I thought, if I can find other cases, and I did many other cases, then I'm up to something very exciting. This is the kind of thing that I was looking for. Here it's even more dramatic. Here we have Black slaves who are suing a bey, a lord, working in a princely estate. And they did this not by going to the Qadi. They did this by going to the police station. And they did this by insisting on some kind of medical expertise being brought into the story. And I thought, this is really fascinating. But then I said, wait a minute, there's so much that I need to find out. First, what is this medical system? And, it took me a couple of years, maybe more, maybe 5 years, I can't remember now, to piece together the story. I had to find out who this doctor was, and that led me to identify this guy, the founder of the modern medical establishment in Egypt, who had come to Egypt in 1825, met Mehmed Ali, the governor of Egypt, in a very fateful encounter in which he told him, I can help you found a medical establishment for your newly established army, because this is what can really protect the lives of your soldiers, cramped up as they are in barracks and in camps and dying like flies with disease. And sure enough, the Pasha gave him the green light, and a couple of years later, he founded the Qasr al-Aini hospital. At that time, it was not yet in Qasr al-Aini. It was in a place called Abu Za'bal to the northeast of Cairo. Later on, 10 years later, it moved to Qasr al-Aini, and it still exists as basically Cairo University Medical School. I followed the inner workings of this fantastic establishment using the records I found about it in the National Archives, including how famous books of anatomy and all kinds of medicine really were translated into Arabic. And I eventually was interested in understanding how dissection for the purposes of medical education was instituted in the medical school. I don't want to spend more time on this because that is not what we're talking about today, but that is really what I talk about in my book, and it's no accident I choose this painting as a cover of the book and also as the opening scene of the book. So that as far as the medical side of the story goes. It's complex, it has many aspects in it, but again, let's just put it on the shelf. The question for me was, what about the legal system? This record that I am reading, these ledgers, this Majlis al-Ahkam, what is this Majlis al-Ahkam? What is this medical evidence being used in Majlis al-Ahkam? How, what is the medical, what is the legal scaffolding upon which the medical evidence is presented in this case? What is this legal system? What does it belong? How can we understand it? Now, I have been working also in Sharia court records, and I have been finding cases in which medical expertise is called upon in Sharia cases. The most interesting for me is this case. It's a fascinating case for so many reasons. I teach this case. It's this one here, the top of this page. It's from 1616 in Cairo. And it's a case of a woman called Tawazzur who is suing her husband for so many reasons. She's suing him for alimony, nafaqa. She's suing him for labor. She says, you know, I've woven his clothes for him for more than 20 years. I need financial compensation for this, but mostly for my purposes. She is suing him for the previous day, and I think that is the straw that broke the camel's back, or one beating too much. He actually broke her arm. And so she takes him to court and is asking for the shara'i punishment, which is diyat madun al-nafs, as for those of you who know fiqh, the blood money, but in this case it's the financial compensation for bodily injury. And the interesting thing, as you can see here at the bottom of the case, the Qadi then punishes him. وأدب على ذلك التأديب الشرعي بعد أن كشف على ذراع المدعية المذكورة أعلاه الشيخ شهاب الدين الدمنهوري شيخ طائفة الجراحين بالثغر المذكور in Alexandria وإخباره بذلك بأن جريدة ذراع المدعية منكسرة الإخبار المرعي. So basically, the chief surgeon, or the chief of the Surgeons Guild in Alexandria, examined the claimant's arm and did in fact prove that it had been broken. And he beat him. as a result. أُدِّبَ على ذلك التأديب الشرعي. And then the interesting thing, fascinatingly, is that the case in the same page, this line here, is what actually happened to the guy. He confessed that he had not been paying her, and he declared that he, from that moment onwards, will pay her a certain amount of money every day. So she won. But the interesting thing for me is this is a typical case again of how medical expertise is presented. It is presented by Sheikh Taifat al-Garahin, who presents it as a khabar, as a report. This is not a shahada, this is a khabar in Sharia records. Again, I don't want to enter into fiqh here, but I want to say that what I am seeing, obviously, in Sultan's case is obviously not this. This is not Sultan's case is not a Sharia case. It does not belong to a Sharia court that was adjudicating the case. So what was it? What is this legal system? Well, sadly, the existing literature did not really help me. Most famously in Egypt, our understanding of modern Egyptian legal history is very much influenced by this book by Ahmed Fathi Zaghlul, who is the brother of the famous nationalist leader Saad Zaghlul. He was a famous judge, or infamous, I should say, because he served the British by serving on the Din Shuai trial. But more importantly for us, he's also the author of this book that does many things, and one of them is to review 19th century Egyptian legal history. And that book became a canonical study for all subsequent works during 19th century, working 19th century Egyptian legal history. They relied on this book. Now, this book disparages the system whose records I'm reading, and dismisses it as a system that was unjust, inefficient, corrupt, because it did not understand or uphold the principle of separation of powers, because defendants were not even allowed to speak in the cases, because some cases took many, many years, and so on and so forth. And it's this very disparaging judgment that every subsequent historian had accepted about the system. It doesn't help. One of these subsequent historians is Latifa Salem, who again is very influential, and her argument in her book, Modern Egyptian Legal System, 2-volume book, is that the Egyptian system 19th century is really going down a secular path. Muhammad Ali was infatuated by Europe, and he did everything possible to emulate their legal systems. On the Islamist side, the Egyptian Islamists, as much as other Islamists, also have the same view. We used to have a divinely inspired system, and we now have replaced it with a positive, imperfect legal system. This is Tariq al-Bishri, who is a very senior and serious judge and author. I take him very seriously, and I think he's one of Egypt's best judges, but also most astute observers of modern Egyptian history. He's also a historian in his own right. And he too says that what we are seeing in the 19th century is an abandonment of Sharia. Now, what I'm seeing in the records do not really uphold this, and I want to tell you how. But before doing so, and before taking you into further details of the case at hand, I want to just acknowledge my debt to 2 men. 2 scholars of 19th century Egyptian law, 2 scholars who are fascinating in many respects, not only how prolific and how humble they are, but because they have a peculiar quality. These 2 scholars in their respective fields are experts in Islamic fiqh. They can write tomes sitting at home on this or that aspect of Islamic jurisprudence. But what they did is different than this. Both of them decided to come to the archives. This is where we met each other. This is where I met them. And Ruud Petters on your right is a more senior person, as you can see from the picture. He's a professor of Islamic law in the University of Amsterdam. He would come in jeans and a white shirt, and he will roll up his sleeves and sit like any MA, PhD student in the archives, 1 year after another, one season after another, poring over the same kinds of documents I was struggling with, and producing studies and articles with the speed with which we were reading them. It's amazing, prolific production. And that is really how I started understanding and helping me to understand what I was dealing with. The same with Ahmed Hilal. This is not his only book. He has, again, many, many studies and articles and books about various aspects of Egyptian, the social history of Egyptian law in the 19th century. Okay, so let us go back to our case happening in the estate of Ilhami Pasha. Remember, the slaves stormed in, gave their deposition. The question is, what did the police do? Well, the police sent not one, not two, but 3 senior police officers to the estate. And with the chief forensic medical doctor. One of them, called Saleh Effendi, he's a Binbashi, very, very, very serious senior position in the Egyptian administration. He goes to interrogate Omar Wasfi. He arrives at the gates of the estate and something fascinating happens. This encounter at the gate, I think, is pivotal to understand what was happening. He was prevented from entering by the chief black Berberi porter, claiming that Omar Wasfi is not inside. Told him, okay, I want to jot down some questions on a piece of paper. Can you please hand him the paper? He said no. While this thing is taking place at the gates, Saleh Bey, the Cairo police officer, is told by one of his attendants that Omar Wasfi is actually escaping through the harem gate on his carriage. So Saleh Effendi jumped on his own carriage and followed Omar Wasfi in the middle of the desert. Now, this scene, I think, is a scene, is a chariots of fire, or not chariots of fire. It's a Ben-Hur scene. I think 2 carriages. I mean, Cairo at that time, it's very few carriages. So to imagine 2 carriages chasing each other in the middle of the desert, with Omar Wasfi wanting to escape into the city itself. Finally, Saleh Effendi jumps on his carriage and takes charge and takes Omar Wasfi to the police headquarters, where he starts interrogating him. In the interrogation, Omar Wasfi denies that he had ordered the excessive beating of Sultan. He says, yes, I ordered him beaten, but only 75 lashes. Now, this figure is interesting because, as we know, as now I'm discovering by using other documents, that there is a ban, a prohibition on excessive beating. There are laws being issued in Egypt from as early as 1829, punishing state officials with a sharia punishment, with the paying of diya, of the blood money, if they cause the death of someone in the process of beating him. Beating itself was not illegal, but excessive beating was. And in my book, I explain how beating was abolished eventually and why. But here we have this, it's already criminal to cause the death of someone by beating him. And you can see here that beating should be on the buttocks and on the feet, and it should not be excessive. And that the sharia would take charge, which basically to pay the relatives the prescribed دية الدية الشرعية إلى أولياء الدم وهي 3600 قرش 3,600 piastres. This is how much the دية was fixed for a male Muslim man. He said, no, I didn't beat him that much. I beat him only 75 lashes. And he said, إن هذه مادة خباثة انطوت عليها العبيد. Those are drunkards. They are in the habit of using hashish. Are you going to believe them and not me? They are recalcitrant, and I'm trying to impose some discipline on them, but not by beating them to death, but within the limits. And he said, this guy who said that I beat him 1,500 lashes and he's counting on the way he beat, if he was busy praying to God, he must have not been paying attention to the number. So he started poking holes in the testimony of the narrative of the slaves. And he started using flowery words, إقامة الحق من وجوب العدل, tautological phrases that are empty. And then in the middle of the interrogation, the police commissioner suddenly found the scribe of Omar bin Wasfi coming with a purse with 150 pounds, which is an enormous amount of money, and putting it on his desk. A clear attempt at bribery. So it was recorded, and this is how we found about it in the records. All of this is recorded. So how does the case end? Well, typically in other cases, visually even, you see the verdict of the case. Let me give you an example. This is another case that I discuss in the book. And you see, this is a it's a much longer ledger, not the same dimensions. But at the bottom of it, you see, even visually, in the middle of the line, وبالمذاكرة عن ذلك بمجلس الأحكام رؤية بأغلبية الآراء بعد تلاوة إفادة الضبطية ومضبطة مجلس الاستئناف وآخر أقوال and so on and so forth. This is the key word. وبالمذاكرة عن ذلك بالأحكام. Upon deliberation about this case in مجلس الأحكام, we give the following verdict. And then they put their seals. Our case doesn't have this, doesn't have a verdict. But instead it has two fascinating things. It has an amazing reasoning of what should be done to Omar Wasfi and why he has to be punished. And the words used are the strongest I've ever seen before or since this case. Let us read them. This is what, as you can see, there's no something in the middle of the line. There's no verdict. وإن كان مواد القتل مما تنظر شرعا وسياسة. Given that homicide cases are to be adjudicated by both siyasa and shara, and I want to talk about siyasa, but even if it is looked at according to sharia, we need a plaintiff, we need a claimant for this case, because this is a slave. So we need to find who his master is and get a power of attorney, توكيل, يقام للتداعي مع عمر بيه, to raise the case against Omar Bey. But even if we manage to do this, the case according to Sharia will end in one of three cases. Either it is proven, or it isn't proven, or the claimant can give up his right for a punishment. And then the reasoning continues. And what will happen in this case? What will happen in the case that the claimants pardon the defendant, that is Omar بوصفي? In this case, it says, فَلِدَاعِي مَا هُوَ مَثْبُوتْ سِيَاسَةً. I'm using all the typos and spelling mistakes of the original. So مثبوت here is تا مربوطة, not تا مفتوحة. This is how it is written in the original here. Yeah, see, مثبوت. Since it has been proven سياسة, not شرعا, that Omar Bey is guilty. Why? Because he had dared and violated the sanctity of the government. And the government does not give up its right for what it had been inflicted by him on it, but has to take its revenge for violating its sanctity. هتك عرضها, حرمتها. I've never seen words that are stronger than this. So Omar بوصفي has violated the sanctity, حرمة الحكومة. And الحكومة does not give up its right and has to punish him for what he had dared to do. فاستنسب بالمجلس أن ترتيب الجزاء عليه في ذلك يكون مفوض أمره للأعتاب السنية. We delegate the sublime thresholds, that is Said Pasha, to deal with the case. Now, when I read this, I was disappointed. I said, where's the end of the story? And is this a case in which the Majlis al-Ahkam was intimidated by the high profile of the defendant, and that's why they couldn't pass a verdict? Where is the verdict? And what did Said Pasha, the ruler of Egypt, decide when the case was sent to him? Now, if you bear with me for another 2 minutes, I want to take you into some details of this case and how it is written, the paleographic details of this case, to give you an example of how we manage these cases and how we can find an answer to the question I posed. What was Said Pasha's response? Now, look at this. In the first line, there is actually a date. We discovered that this matbata, this record of this case, is actually compiled of 2 separate summaries of police reports. The first of which has the date here, dating 15th of Rabi' al-Thani, 1275, number 72. This is the number and the date of the report of the police, Cairo police, to Majlis al-Ahkam. And then they summarize it. And then I told myself, wait a minute. I have a date and I have a number. I can use it to find not the summary, but the original of the police report to get the case fleshed out more. This requires me to leave Madame Sausan and go to Madame, I think was Shukriya or Khairiya, I can't remember, who is in charge of another archival unit of the Dabtiya of the police of Cairo, or not Majlis al-Ahkam, but something local, not national, as they call it. There is Siyadiyya and there is Mahalliya, and the Dabtiya is with the Mahalliya. Mahalliya is Madame Shukriya. So I went to Madame Shukriya and asked her, where can I find a case, the records that cover this period? And sure enough, I found it. And that's how it is reported. You can see in the police report, it actually has the same number. You see 72 here, 72 here, and the same date. So this is one report. And then later in the record of Majlis al-Ahkam, there's another date. because it's another report, and this is the second police report, and that is the incident, the details of the bribery incident. And then when I was looking, I'm trying to find clues. Where can I find an indication that can help me locate the response of Said Pasha? I discovered this notation in the upper left corner of the case that says أرسلت المعية بإفادة رقم 22. It was sent to the Vice Regal Cabinet, this is Said Pasha's cabinet, with a cover letter dated 22nd of Rabi' al-Awwal, 1275, with that number. This is either 12 or 13. So again, I go to Madame Sausen again, because she's in charge of the Siyadiyya. I tell her, can I see the records of the Ma'iyya, the Vice Regal Council of Said Pasha, responding to this letter? I have a date, I have a number. And sure enough, I found it. Sadly, I don't have a photocopy of it, but I eventually found Said Pasha's response. And Said Pasha decided to exile Omar bin Wasfi from Egypt altogether. And he issued firm orders to governors of all the ports of Egypt to prevent his return. Now, this is fascinating. We see Said Pasha here taking the advice of and the recommendation of Majlis al-Ahkam for Omar bin Wasfi to be punished and punished severely. It is at that time that I realized that this encounter that happened at the gate of the estate is probably as important as the deposition of these black slaves against Omar bin Wasfi. This encounter between an official of the state and an official of the estate is very significant. It's as if the Majlis al-Ahkam, in making its recommendation to Said Pasha, is telling him the following. Is telling him, you have been ruling this country because you inherited this from your parents and your grandparents. Egypt is being ruled as household government. And according to household government rule, the estate is an estate that you own, all of you, this family. This is your grandnephew, he can do whatever he wants in it. But if your rule is to stay and not wither away, you have to give the police, who are not related to you by blood, the right to adjudicate this case and to step on the necks of this elite that think that they can take the law in their hands and kill a black slave. So the question is Egypt a state or an estate? Or to use the Arabic words, these are my words, by the way, not obviously in the records. But the estate in Arabic is called the Daira, Dairat Ilhami Basha. So is it the Daira or the Dawla are we talking about? Is it the estate that will last, household government, or the state? And Said decided, I will forsake my family, and Ilhami Pasha, my grandnephew, and his employee should be punished and banned from Egypt. So we are dealing with a state that's a powerful, efficient, and very confident. And I hope I have shown you in the registers, the documents, the paperwork of this state, how efficient it is. It's incredibly efficient, infinitely more efficient than the present Egyptian state, infinitely. These records, these bureaucrats whose records I'm reading are much more eloquent and efficient than Madame Sausen and Madame Khairi, with all due respect to them. This state is being founded by an army, but the law plays a very important role in it. And the various aspects of the law, and I want to start to sum up here, but in summing up, I will be making some very important arguments. So bear with me for another 5 minutes or so. This state is being founded on law. It's a state of law. And the law takes various forms. It takes a form of legislation. Muhammad Ali is in the habit of issuing laws as early as 1829. And we saw the compilation of these laws under Ismail in the 1860s. You can see here visually a state that is going in its own archives to try and deduce from it what it had legislated to come up with law, with principles, with abstract ideas and principles of law. But these laws do not implement themselves. These laws are called qanuns. These qawaneen do not implement themselves. They're implemented in majlises, in provincial councils that are stacked in a hierarchical fashion with provincial ones, and these are just a sample of them, there are much more than this, and then 2 appeal majlises, and all of this is funneled up to Majlis al-Ahkam, whose records I'm reading. The most interesting thing about this system is not only how organized and hierarchized it is, but this system works in tandem with the Sharia codes. It works in tandem with fiqh. This is the very philosophy of siyasa. The logic goes back to the summing up that I mentioned of the case. When they say, if we were to follow this case only according to fiqh, which they call sharia, we will be left short because the claimants can pardon the defendant. So here is one of the big logics, one of the big reasons behind the logic we're talking about. We're talking about a siyasa system that is brought into play to complement rather than supplement sharia. To complement specifically fiqh when it comes to adjudicating things like homicide. Why? For the following 2 reasons. Homicide in Islamic law is primarily private law. So what will happen if the claimants decide not to adjudicate, not to bring the case in the first place, or to pardon the defendant? Any self-respecting state would say this is not enough for our purposes, maybe enough for the 2 parties, but for our purposes, for the purpose of society as a whole, the defendant has to be punished. The second thing is how to prove homicide. In fiqh, homicide is a had, is a very serious offense, can only be proven either by confession, iqrar, or by 2 witnesses, witnesses by 2 upright eyewitnesses. That's a condition that is really difficult, if impossible, to satisfy. Most murders do not take place in daylight to the degree that we will find 2 men who are willing to testify and whose testimony coincide to the smallest detail in what they had witnessed. It is because of this that these problems in fiqh, raising the bar so high of establishing proof, that jurists were trying to find a way around it. There's a fascinating, I'm going to skip this case. There's a fascinating article by Baba Johansen, published in Islamic Law and Society in 2002, based on the works of these 2 towering Mamluk era jurists, Ibn Taymiyyah and Ibn Qayyim al-Jawziyya, about evidence. And what they are basically saying is, we will go with dalala, we will go with circumstantial evidence. We will not insist on verbal acts, that is confession or an eyewitness account, in order to establish legal proof. And since that time, as you can see even from the titles of their books, siyasa became shar'iyya, became part of sharia. Siyasa is part of sharia. Ruud Peters, in his own work, did a fascinating statistical analysis of homicide cases adjudicated by one court in Cairo in 1 year in the 18th century. Can't remember the year. And he reached the conclusion that 95% of them are not proven. They do not end in a qasas punishment. So the problem with qasas is not what modernists say, that it is inhumane, cruel punishment. The problem with qasas is that it's very difficult to execute, to implement, because it's very difficult to establish proof for a homicide case. The problem then is, for a society or for a state that respects itself and wants to establish a deterrent for this very serious crime, is a serious loophole. This loophole is filled in with siyasa. Now, this siyasa is not what Joseph Schacht has argued, secular. This siyasa was what Ibn Qayyim al-Jawziyya and Ibn Taymiyyah are saying, part of Sharia. And there's nothing more eloquent visually than that represents this idea of how siyasa is part of Sharia than the official coat of arms of the Ottoman state. It's much later in the 19th century, but it sums it up. We see here power of the military, but here the state cannot function without justice. And justice here is represented by a balance, but also a scale, but also by two books, a red one and a green one. And the green one is fiqh, and the red one is siyasa. Siyasa has always been part of Sharia. So let me sum up. I have 5 points of conclusion, and mention them in one line each. First, contra to Latifa Salim, what we see in 19th century Egypt is not a story of secularization. We see an evolution of the Egyptian legal system, but this evolution is taking place within Sharia, not outside. Sharia was not abandoned. Secondly, in contradistinction to Bishri's argument and that of multitudes of Islamists, the Sharia we're talking about is not the Sharia of the Fuqaha only. It is also the Sharia of the state, that is the siyasa. Siyasa is an integral part of Sharia, and we cannot understand Islamic legal history without taking into consideration the state. The state does not interfere in the Sharia code, but it builds a parallel legal system called the siyasa to help the qadis, to help society find solutions that fiqh alone chose not to resolve. And what was novel then in 19th century Egypt? If Sharia has always existed from day one of Islamic law, what we see in 19th century Egypt is not a bid'ah, is not a deviation from Sharia, and definitely not secularization, but a bureaucratization. It's a bureaucratization that comes with the establishment of a modern state, a modern Egyptian, Muslim, confident, scientific, and modern Egyptian state. And lastly, in contradistinction to the argument of post-secular scholars like Talal Asad and Wa'il Hallaq and they're very influential books. What we see in modernity is not a divorce between law and ethics. It's not because this divorce did not happen, but because the question is what kind of ethics was law wedded to? Law in pre-modern times was wedded not only to fiqhi ethics, but to siyasi ones. And together, they are sharia ethics. I think I will stop here.
Let me first be the first to thank Professor Fahmy for that talk, and I'm very grateful for that. I would, of course, welcome questions, and so for the attendees who wish to ask a question, please either raise your hand or put it in the Q&A box. But I'd like to begin with a couple questions of my own to get us started, if that's all right with you. And so I want to take your last point, Professor Fahmy, on thinking about siyasa as part of the siyasa and fiqh, as part of a shar'i system, and thinking about it in the context of bureaucratization. And I think of some of the work, like Karen Barkey's work on empire, thinking about empire as a decentralized mode of governance. I'm wondering if what you might also, another way of putting your argument is that if we think about competing models of governance, centralized versus decentralized, imperial versus the modern state, or the rising notion of the modern state of the 19th century and onward, is your argument located in that world where we're really thinking about shifting paradigms of governance? Because the 19th century is a very interesting time to think about the state, not just in Egypt, but in the United States. There's William Novak's work about the 19th century United States and the legislative framings around police power. We see 19th century conversations around codification in Germany and others with Savigny and Thibault. And so I'm wondering to what extent there's a conversation here that you're entering into that's not just about Islamic studies, but really about the modern state as a particular technology of governance, distinct from what we may have witnessed during imperial models, where governance was perhaps more decentralized, and even earlier models where it was perhaps much more informal and imagined.
Yes, I think, thank you so much. That is very much part of my argument. And one of the things I try to, the way in which I try to flesh out this argument is to speak about the facets of this state that distinguish it very much from earlier states. And it goes along the lines you're suggesting. These are centralized states, and they're not just bureaucratic states, because the Ottoman Empire has always been a bureaucratic state. But the Ottoman Empire of the 19th century is different from the Ottoman Empire of the 17th century. And this difference can manifest itself in the kind of records, in the kind of documents, and the logics behind them. So the things that I concentrated on is ID cards, passports, proofs of residence, how people identify themselves, basically, how we are shifting from a notion of identity that was socially constituted, where people, a woman going in front of a qadi, well, of course, or a man for that matter, would not say, here's my driver's license. She would say, this is who I am, based on the testimony of these people I'm bringing with me, and they testify to my personality, not only to my person. And in the 19th century, that becomes redundant. The state has a technique to pluck out the individual from that context and does not see the personality, but sees the person and sees then weaves around him, like Foucault had described, discourses and practices that make this person legible to the state in a different way. So it becomes a much impersonal, to play with words, system, because the person had been plucked out. But it's mostly what I concentrated on is these bureaucratic devices of how people moved, how people identified themselves, how people carried themselves in front of this state. And the difference between this, at the same time, maybe the same case, how a woman who's having a certain dispute would present her case in front of a qadi very differently from in front of a majlis siyasa. Not only the legal stratagems, but the basic assumptions of just proving who she is very different. So this is one of the, this is why I'm saying we're dealing with something old, but very new. So the siyasa is old, but this 19th century siyasa is very modern.
Thank you very much. We have a couple questions for you. I'm going to ask Yusuf Sufi too, who's raised his hand to ask his question. Yusuf, you'll need to unmute your speaker.
All right. Thank you so much, Khaled. Really appreciated the talk as always. My question relates to your point that siyasa has always been part of the sharia from day one. You've pointed towards the long-standing importance of siyasa when you talk about Ibn Taymiyyah and Ibn al-Qayyim al-Jawziyah, but I'm thinking about a period before that. I'm thinking about during the Abbasid period. What proof do we have? What evidence do we have that Sharia was very important? That siyasa was very important to the Sharia during that period of time.
Thank you so much, Yusuf. This is a wonderful question, and it's a question that takes us to sources. Now, definitely, siyasa never produced the literature that fiqh produced. It never produced the records that we have in fiqh. And even in Sharia court records, we don't have extensive siyasa records. I mean, what I'm discovering in Egypt is maybe the only complete archive of a siyasa system that one can identify. But my answer to your question is, maybe we haven't been looking. Maybe we have been too content to identify Sharia with fiqh, not realizing that there was always another aspect of Sharia. Now, this other aspect, as I say, it's never that elaborate, it's never that intricate, but it is always there. Now, you find records, references to the siyasa in chronicles, and even in fiqh books. You find in Al-Ahkam al-Sultaniyya of Mawardi references. I mean, he says siyasa is as old as the Abbasids. And if we make the analogy, well, qada had a very rudimentary form under the Abbasids. It had not yet been elaborated the way we see it under the Mamluks or under the Ottomans. And I think that along the same lines, the siyasa systems that existed, sometimes called mazalim, sometimes called siyasa, and other names, did exist. There are references to it in fiqh books, in the chronicles. We don't have records of them, but any Mamluk chronicle will tell you in details about how the sultans used to adjudicate and to sit in Majlis al-Adl, which is different from Majlis al-Hukm, which is different, in other words, from the Sharia court. So I think this is a question of historiography and sources and being attentive to the different and to look for it and to flesh it out. And now we are starting to do this. There are now more and more scholarship on Ottoman siyasa. For the past 25, 30 years, we've been really fascinated by the outpour of scholarship using Sharia code documents from the Ottoman times. Now, more and more people are being attentive, whether working in Egypt or in Istanbul, in Turkey, on the Divani Humayun or Diwan al-Wali in Egypt. James Baldwin has done this on 18th century Egypt. There are, Boğaç Ergene and others have worked on this on the Ottoman Empire in earlier times. So my answer in short is that the evidence, the textual evidence is definitely not as extensive, prolific, intricate, or elaborate as that of fiqh, but it exists, and it is now a question for historians to flesh this out and to try and explain how this has evolved over the centuries.
Thank you. Jeroen Gahan of the University of Alberta, a former grad of ours and now professor there, actually raises an interesting question for us to think about, and I want to pose to you. She wants to ask about the siyasa sharia complementarity in light of questions of bureaucratization, but also secularization. So her question is, if we think about secularization as a state process that changed the relationship between Islam and rule, could one thereby trace through a focus on secularization a shift in the relationship between siyasa and sharia? Did bureaucratization of law change the relation between siyasa and sharia? Is it possible to conclude that sharia became increasingly a matter of private and personal disputes, while siyasa was a matter of public order and the character of the public?
Again, thank you for the wonderful question. As you could see, I stopped my narrative in a crucial period in the 1880s. Of course, the story continues to the 19th century, the end of the 19th century and the 20th century, and one can say it continues till today. I have a couple of students, Ahmed Izzat here in Cambridge, who's working specifically on this, on how we can understand the evolution of law in Egypt, which has been typically seen as only that of secularization, of limiting Sharia to the private realm, to the questions of divorce and marriage and so-called personal status. And the state takes on, Sharia, lock, stock, and barrel, especially with regards to criminal law. And he's basically saying, wait a minute, let us see how this evolution has taken place. And his argument is that the change is taking place on the ground of Sharia, not outside it. Now, of course, there are serious transformations that happen as a result, again, of modernization, bureaucratization, not as a result of secularization in the old sense of the word, the sense of that Tariq al-Bishri understood it. In other words, there are a number of Egyptian and Muslim elites who became westernized, who decided that the main reference point is Western law, and the question is how to adapt our system to fit in it. And they abandoned Sharia. This I do not see. This is not what is happening. And people did not abandon Sharia. But as I think your question indicates or hints, there is nevertheless fundamental differences. And one of them, I think, is crucial, relies on what I mentioned in answer to Professor Emon earlier, which is what happens when this new identity appears? What happens when this bureaucratization gives rise to a new notion of identity? And one of the repercussions, I argue, I don't really argue, I suggest without proving it, because that's another project, that the principle of equality becomes possible because of this. Not equity, which is what fiqh is based on, but equality. And equality between Muslims and non-Muslims, between men and women, between slaves and free men, changes the very nature of the law and the very philosophy of the law and of the legal system, especially when it is practiced in this way. So even though this was not intended, but this is how I would like to understand and to study these transformations, to study them in practice, rather than to try and use the tomes, which is what Asad and many of his students are doing, to try and identify some key legal texts from the end of the 19th century that are exemplary of a rupture that happened. This is very fruitful in and of itself. But I want to supplement this methodology with a methodology of what did people actually do and how did, like an anthropology of law, to explain how these transformations can better be understood, of the transformations that can be lumped under the heading of secularization. My argument, again, is that the archives matter. And I don't mean the archives. I mean the ethnography, the archive of what happened, not what people thought, but what they did in adjudicating their cases in court, matters to be able to understand the transformation in the legal system.
So we have a question. I'm going to collapse it in the Q&A. The one person wanted you to revisit your discussion of halak and asad that you allude to at the end. But I also know my colleague Jens Hansen, who also has a review article on halak, has his hand up. So I'm going to ask Jens to, perhaps we can bring Jens into this conversation, though not framing his question for him. I'm sure he has many other questions, but I wanted to bring together this one question in the chat function with Jens. So Jens, please feel free to ask your question.
Thank you very much. Thank you, Khaled. A wonderful talk, just riveting the way you bring to life and reconstruct Egyptian social history to make a real contribution to the study of Islamic law. I guess my question is more one of comprehension, and I ask as a fellow historian, not so much as a critic of Wael Halak's book, Restating Orientalism, if you don't mind, Enver. So we have an axis here, or a couple of axes. One, and they're sort of against the continuity and change sort of a story. So we've got the estate gets challenged by the state, and Da'ira loses out in this episode that you recreate to the Dawla. On the other hand, you're making an argument for sort of the permanency of siyasa inside Sharia. And I wonder if that is not perhaps a contradiction. So, or I wish you could prove me or tell me that I'm wrong. Because if you're making an argument that the state, it needs a state for siyasa to help challenge the estate of Hilmi Pasha and the whole dynasty, right? Then that is a different siyasa than when Ibn Taymiyyah kind of formulated it and inserted it into the canon, is it not? And so the follow-up to that then is, what changes in your challenge to sort of Islam as a discursive tradition, or by Talal Asad's sort of hypothesis, right, or research agenda, and what changes to the idea that Islamic law cannot be modern, while halak. It seems to me you might be, can I push you to argue that Islamic law with siyasa inside it has never been unmodern, or has always had the state somehow already factored into executing its precepts? I guess.
Thanks, Jens. Thanks. That is a wonderful set of questions and thoughts. So let me agree with you on the last bit, and then we go back to the earlier part of your question. Yes, my argument is we cannot understand Islamic law without taking the state into consideration. My problem with Wa'il Hallaq's book and with Talal Asad's books and scholarship is that I do not see the state. I do not see a state. I don't know where this is taking place in first, like as a historian, I don't know where this is happening. Which part of the Muslim world, which century, which period? But more seriously, I don't see the coercive power of the state. And the state matters a lot in how Sharia functions, even Sharia courts. Now we understand. Of course, the judge is an independent player, as Wa'il Hallaq has explained in his copious scholarship. But it doesn't mean that the state does not regulate various aspects of even the functioning of the judge. The most famous example that many people have been working on is, let's say, the case of Waqf can be an interesting case, but case of abandoned wives. When is it that a wife whose husband had abandoned her on a trip and never came back can be declared divorced or a widow, so that she can be married again? Now, this is a serious problem, it's a serious societal problem. We know from the records that different women would go to different judges depending on their madhab. And there are different madhabs, different rulings per madhab. There is a madhab that says we have to wait until the last person of the cohort of the husband had died. Others say 99 years. And then the Hanbalis have an easier answer. I can't remember whether it's the Hanbalis or the Shia. I think the Hanbalis have an easier answer. So the state, the Sultan, the Ottoman Sultan, would issue a qanun, a circular, to the qadis to say, when you have a case like this, you are henceforth relegated to that madhab, because that's the most lenient madhab, and to rule according to this madhab. Do not rule in it yourself if you do not belong to this madhab, but refer to it to the Hanbalis. Now, this kind of intervention is what we haven't been studying. And so this is not a blatant example of siyasa, the way one can think of when they think of siyasa, but it's the presence of the state concerned about the functioning of the qadis. Another example is, what do we do with an incompetent judge or a corrupt judge, which I have dealt with in the 19th century. One of the functions of the siyasa councils that I haven't described or talked about at all in my talk is this function, the siyasa function. The siyasa councils functioned as not appeal, but an oversight. There is a judicial oversight of them over the shara'i majlises, not based on siyasa, but based on fiqh, because the siyasa majlises has muftis of all madhabs, and their duty is to make sure that the not only lower councils, but that the sharia courts have issued, that the sharia judges have issued their verdicts properly according to their own madhabs. Now, this again, we don't hear about in fiqh. This is the state making sure that there's some kind of consistency, but also oversight and responsibility over the Qadi. So then it becomes, when you think about it, you start thinking, we cannot understand the Sharia court in isolation of the state that exists in the legal sphere in various ways. And that the Qadi is not the only legal player in the field. There are other people that we have to take seriously, and they're not secular the way we understand modern secularism. So this is my critique of Halak's impossible state, not the book you mentioned, that it doesn't take the state seriously. There's no state at all in it. With regards to Assad's notion of discursive tradition, it's a very valuable, as we know. It has generated enormous amount of scholarship, and it has enabled people to understand Islam historically and ethnographically across many societies. My question is, whose discourse? So there are many discursive traditions in Islam. There's a fiqhi discursive tradition, which I claim Assad means. But there are other discursive traditions, not only the philosophers or the artists or the udaba, but the siyasa discursive tradition. The multitude of books on mirrors to the princes. This is politics at the very high order, and it's also legal, and it's definitely Islamic. So what kind, and sometimes they talk in tandem the way Nawardi would like us to understand. Sometimes there was clash. The way Yossi Rapoport, in his account of how the fuqaha under the Mamluks understood siyasa and dismissed it as an incursion and as an importation from the Mongol Yasa, there can be tension, but it existed and it was Islamic. It wasn't Mongol. It was an Islamic indigenous attempt to uphold law and order. And I think it is attention to these kinds of questions that can allow us to get to the nuances of Islamic law in action over the century. And I hope in my classes in the coming 3 days, we will talk about Hizbah and we will talk about Qada with the students, and we can touch upon this. I hope I have answered with some of your questions.
Wonderful. Thank you so much. I'll unmute now.
Thank you. Thank you, Jens. We have a question from Islam Daya from Berlin for you, who asks, in terms of legal historiography, how do you explain the apparent ignorance of 20th century historians like Latif and Bishri of the 19th century social realities that you describe? Is it the outcome of ideological discourse around modernization and state building with Sanhuri and so on, or a lack of attention to social practice?
Again, wonderful question. It's a good question because both, as I said, Bishri is not only a towering judge, but he is a historian, and his work on the 20th century Egyptian history is some of the most insightful. I disagree with it fundamentally, but I respect the scholarship and the effort and the erudition and the thought and the perception of what was happening. It is an attempt to understand the Nasser state under Abdel Nasser in the 60s by going to the earlier period. His account of the history of the Coptic church is also fascinating. But somehow, when he comes to understand the history of his own profession, of Qada, he has a blind spectacles. He's not interested in practice, as you are indicating. He's not interested in the history of legal practice as part of the history of law. And I think this is a crucial omission. Secondly, to give him credit, to give everybody credit, The records that I'm talking about have only been recently discovered. We're talking about maximum 20, 30 years. Now there are more people working on it, mostly as sources for social history rather than legal history, because of the details that I attempted to bring across in this talk. There's many, many intricate social details of social history. But yes, there is a problem of lack of sources. And because of the historiography that also blinded us, the way I tried to indicate very briefly when I spoke about Ahmed Fathi Zaghlul's book and others. There are other canonical books that became stumbling blocks. They established a barrier that prevented people from actually reading these documents. And then these documents themselves were not really available. Let me end with just an anecdote. The Siyasa councils, people didn't know what they are. They thought Siyasa means political. But these councils themselves were sometimes called provincial councils. That is why Madame Khayriya took it, because it's part of the local government rather than the national legal hierarchy. And then they were banned for a while, and they were called al-Majalis al-Mulgha. So as a historian, you go to the archives, sometimes you come across an archival unit that says al-Majalis al-Mulgha. So you dismiss it because it was banned. You subconsciously don't take it seriously. Then they tell you, no, they are provincial councils, Majalis al-Aqalim. So again, you think it's concerned with municipal issues about cleanliness or public hygiene or local taxes or whatever, You don't think that they are legal. So I think the classification also in the archives, in addition to the many problems of the archives in Egypt, have made it impossible. And this is why I keep on talking about this. And this is why I also tell my friends who have a literary talent to tell them, look, these are wonderful stories as stories go. If you can only go and have access to them and bring them to light. But there are security clearances that make it impossible, nearly impossible for people to go. The average number of visitors in the Egyptian National Archives is less than 10. We're talking about millions and millions of registers that go for hundreds of years. So it's a scandal. So I don't blame people for doing what they have, given the scholarship and the sources.
Well, on the issue of the National Archives, Delbar Khakzad actually asks about accessing the National Archives. So perhaps you can give us some insights here. Specifically, Delbar's question is there any way that scholars can use the National Archives in this context of pandemic now? Is there an online access? Delbar in particular is looking for a Persian periodical published in Egypt in the end of the 19th century and preserved in an Egyptian archive. How does one obtain access? Is it difficult, as you were mentioning earlier? And particularly in the context of pandemic, is it even possible?
Well, the pandemic, I wish it were the pandemic. It isn't. The pandemic might have made things a bit more difficult, but our problem is not with the pandemic. Our problem is with the security state in Egypt that is looking at scholarship with suspicion. These national archives are not considered ours. They're the state's archives. We are intruders at best. We are spies at worst. And this is how we all have been treated. We are ones of the few lucky ones who have made it. I consider myself to be extremely lucky to have had access to the archives with my students 10, 15, 20 years ago. Now, permits are rarer and rarer. No answer is the typical answer to your request. You can wait for months on end to receive an answer to your application. The application has become much more rigorous, much more difficult, and much more informed by security concerns. They think of you as a spy. Why is it that you leave your comfort overseas and come? Where did you learn your Arabic? Why are you here? Why are you looking up into these documents? This is if you're a foreigner. If you're an Egyptian, it's even more suspicious. Why are you doing this? What kind of information are you looking at? And everything you do will be looked at with suspicion. Even if your project is about 17th century Egyptian carpet design in Akhmim, in Upper Egypt, they will say, are you interested in confiscated property that the state has embezzled when they appropriated the waqfs? And this is what you really are after. And we are after you, we are monitoring you. So with this mentality, and we are being ruled by a military dictatorship. It's not the pandemic. It's the military dictatorship that rules Egypt now, that is closing the archives and really, really in so many different ways fighting academic research and academic freedom. Academic research is another way of espionage. We're not going to tolerate it. We have much more serious things at hand. Now, the last thing is that the periodical you're looking at is most likely not in the National Archives, in the National Library, because there's a National Archives and a National Library. And the National Library has a manuscript section, which is different from archives. So it has single documents, old Qur'ans or illuminated manuscripts, but it may also have these precious old periodicals. And that is definitely not in the National Archives, Dar al-Wathaiq, but it will be in the National Library, Dar al-Kutub, and its different branches. It doesn't mean that it's more accessible. I'm just saying that this is where you should be looking.
Thank you. We have two last questions from our doctoral students who will also be joining you tomorrow in your masterclass. So why don't I give you both questions and then you can take them in the order that you prefer. Muhammad asks us about your discussions about Ibn Taymiyyah and Ibn Qayyim al-Jawziyya regarding their works on siyasa sharia, wondering epistemologically, how might one think about what they're doing? Are they trying to integrate siyasa as if it were already sharia, or are they trying to post hoc legitimize it after the fact as a feature of sharia? Nader asks about the Egyptian state in the 19th century and asks if the state is only utilizing or worse, expanding the field of operation of siyasa rather than secularizing. How do we explain the ultimate abandonment of the Sharia penal system and the introduction of a Western-inspired civil code on family law? Was there no connection between this final, quote, secularization on the one hand and the bureaucratization on the other? And so it seems like in many ways is talking about the development of a more secularized legal system. So those are two very different questions, two different time periods, but both speak to your work.
Again, wonderful questions. Let me start with Muhannad's. Muhannad, I think you phrased it very well. I would tend to believe that they were trying to legitimate an already existing practice. They're not trying to epistemologically argue for a new deviation from existing practice. I think they understand that siyasa is here to stay, that the siyasa councils and the siyasa officials have something to say, and that it's enough is enough, and let us get down to business. Let's not keep on arguing whether this is legitimate or not, but let us declare once and for all that this is part of Sharia. This is how I read Johansson's article about these two towering figures' contribution to the debate. Now, the second question, I forget the name of the person.
Oh, it's Nader.
Is what I indicated before. I am trying to say that we should look at this question with fresh eyes. And we should, if, let's say, you concentrate on homicide, let's say we concentrate on capital punishment. And then we need to understand the different permutations that have taken place in the 1880s, 1890s, 1900s, different penal codes that were passed in Egypt that have A, transformed the meaning of homicide, B, established new techniques of proving it, C, gave it different punishments, including capital punishment, and then D, gave different conditions for qasas to be implemented. To argue, to say what I said in a different way, I want to understand the archaeology of the Mufti in the passing of capital punishment sentences in the Egyptian legal system today. The Mufti's opinion is sought. It's not binding, but it's sought. It's mandatory after the Supreme Court had passed a capital punishment sentence. The sentence has to go to the Mufti to be not ratified, but for his opinion to be for consultation. Now, the question is, where is this coming from? This is a trace. And the question is, how do we understand the trace without immediately jumping to the conclusion that this is an attempt to elbow him out? It's very tempting to reach this conclusion, but we haven't done our homework yet. This is what I'm saying. Some of my students are actually doing this right now to understand what is happening to the Egyptian penal system, step by step, away from the discourse of colonization and away from the discourse of secularization, to take it seriously, to take it on its own terms and follow it step by step. And one of the things, for example, and this will be my last point, I met Hilal, who's the name the scholar I deeply respect. I met Hilal, I just finished a 7-volume book on the Egyptian Ifta, on the history of the Mufti institution, from the day it started till today. And that is where this is the kind of work that needs to be done to understand how permutations happen. And I think the field jumps to conclusions without actually doing the archival, ethnographic, detailed work. And sometimes explicitly, all of this is sometimes dismissed as not important. No, it is important. We need to know the details before jumping to conclusions.
And with that, I'd like to just take a moment to bring our session to a close. Professor Fahmy, you've impressed us all with the depth of the analysis, your attentiveness to detail, your emphasis on archive, including the archive that's missing as we think about the Abbasid period and that which is not there. And I want to just say thank you on behalf of all the attendees, on behalf of the Institute of Islamic Studies. It's been a real pleasure having you today to learn from you, to hear not just about your book, but your process, the process of studying, researching, and examining records in a way that that we too rarely get a chance to do with scholars like yourself. So to the grad students who'll be joining you tomorrow, they have quite a treat in front of them. So thank you for being a part of our week. For those of you who joined us from across the university and other parts of the world, thank you for joining us. And this was our first major event of the term. We'll be having many others. Actually, I was very delighted that Islam Daya was here. He'll be one of our speakers later in the academic year. So welcome to you, Professor Daya. And Professor Fahmy, I will see you tomorrow at 10 o'clock. And otherwise, anyone who wants to reach you can contact you via email. But thank you very much for your time, for your energy, your passion, and for the depth of analysis.
Thank you so much. It's been a wonderful opportunity.
Thank you. Good night, everybody.
Night.